Shaw was this case that we started with a couple of intakes and a dream.
So one of the first cases that I worked on as an attorney and then as a legal director at the affiliate was the case against the Kansas Highway Patrol. So it's a case called Shaw v. Jones, and it was actually on behalf originally of 3 individuals who had been involved in 2 separate traffic stops on Kansas highways by members of the Kansas Highway Patrol, the KHP.
What happened with Shaw, though, was we got these really consistent stories from just 2 people, but we got these 2 really consistent stories of someone being stopped by a Kansas Highway Patrol officer in western Kansas when they were coming back or going to Colorado. And what happened was they were, pulled over for kind of a traffic infraction. The officer would ask for consent to search their vehicle. They would say no. Then they'd say, if you say no, I have to bring a dog out. And then they would say, I'm still saying no. And then they'd bring a dog out. And it was this big, long detention. And I feel like it was the same dog for both of our clients. That dog was a menace. He was named in a lot of stuff.
Police officers need something called reasonable suspicion in order to detain a motorist for longer than it takes to just complete the traffic stop, right? A normal traffic stop includes giving over your license and registration. The officer then runs those, makes sure there's no outstanding warrants. They write you up a traffic ticket, or they write you up a warning. They come back to the window, they give you that paperwork, and you should be free to go. But what was happening in these stops is that the officers were then trying to engage the drivers in additional questions with the goal of detaining them, calling out a canine dog to sniff around the car, and eventually searching their car for drugs. They were doing that without adequate reasonable suspicion, without any real evidence to point to that a crime had been committed or was about to be committed. And that violated the Constitution.
It wasn't something that was really obviously a institutional problem, but we thought it was similar enough what had happened to them to start doing some digging. Zal and I started making requests to the Highway Patrol. We also, just for their policies and their trainings, just kind of general Kansas Open Records request. We also reached out to the public defender's offices that were along I-70 because we were like, there's something about this road, the main, highway in the state. And the more we heard, they're like, oh, well, there's these 2 people who complained to us, but there's a lot of people who have won suppression hearings based on this tactic in the defense, in their criminal defense cases. And then also, just the criminal defense attorneys we were talking to be like, oh, yeah, that's a huge problem. They do this. And then also we looked at their training and we're like, oh, they trained them to do this thing.
Shaw was a really strong case that we were able to bring because people had come to us first about what had happened to them.
One of the more interesting things about this case from an investigation perspective was that as soon as we filed it and news got out that this litigation was happening, we started hearing from people all over the country who had driven through Kansas and had this exact same thing happen to them, which showed just how widespread the practice had been.
It was a case that was really impactful. It impacted every single, not only Kansans, but people who were just traveling through.
What the case found and what the investigation around the case found was that KHP officers were trained to engage in what they called the Kansas two-step, which was a maneuver where they handed the paperwork back at the end of the traffic stop, took 2 steps away from the vehicle, and then immediately reapproached the driver and said something to the effect of, hey, can I ask you a couple more questions? The driver at that point thinks they're just still being detained and that they have to keep answering these questions. The KHP officer thinks that this has now become a consensual encounter. And what our investigation and litigation in the case showed is that these drivers didn't feel free to leave. And in fact, they couldn't pull back into traffic on an interstate with a KHP officer standing right at their window again. They felt pressured into answering these questions, and the whole operation was dressed in an attempt to violate these drivers' constitutional rights and get them to give up information so that the officer could get inside their car and search for drugs. And that violated the Constitution, and that's what a federal district court in Kansas found.
I think the two-step also, at the two-step in this sort of lip service to consensual interaction, it just sort of shows to me there's a lack of seriousness to that. Is you don't actually, there's no way that you as a human believe this. Maybe as a officer of the law, you sort of are, I think there's a very blatant unseriousness, insincerity to that entire concept. And they built an entire training program from that.
I think at first the court was skeptical of our claim, and maybe for good reason. There does seem to be quite a bit of deference to law enforcement to make sure that they can do their job safely and effectively. But once we were able to put on the testimony of our clients and of experts and of KHP officers themselves, I think it became very clear to the court that this was a very elaborate ruse being run by the Kansas Highway Patrol, and that they were deliberately violating previous law written by the 10th Circuit Court of Appeals in order to get access to motorists' cars.
In our research, as we were putting things together, we knew that the Kansas Highway Patrol had been sued for this in the past. Not the whole agency, but one individual officer, Vasquez. Yeah. And so that was another thing that I think drove us a little bit, was like, your officers have gotten in trouble for this in the past. You set wonderful 10th Circuit precedent for everybody, for people like me. But, and you're still doing it. And there was, I think, a real insistence and a resistance on the part of the state that, like, we should be able to do interdiction work in this way, even if it violates people's rights. And I think that, like, that was one of the things. This was a clearly established violation, and they kept going. And then we sued again, and we were winning on all these motions, and they kept going. And so that was disappointing for me as a Kansan who would like to believe in my governor.
We were able to win and obtain an order from that court prohibiting this practice going forward.
A lot of people said that, like, I used to really trust law enforcement, but this was so obviously unfair that I just can't. It changed their perspective of law enforcement forever.
They were very courageous people, and it was really obvious that the whole experience had really damaged them emotionally to where they didn't want to ever come back to the state of Kansas again.
Yeah.
But they came back for this trial. They stood up and did what they needed to do, which is a really brave thing that they did. And it's a brave thing for any of our plaintiffs to get up and do that.